Ebusia asem kese asem no enya jeta ene sai Chairman Wontumi ubeka ya sensia NDC amanyokuo no etimi eba power pa ena Chairman Wontumi edi Cõurt akwani basa entu beka ya in 2025 the whole year ni nyina no otimi edi Cõurt akwani aba ena afensu no ekokudin in 2026 wose di mu akoniaba abesi ne abusua ene na final judgment no enya akonya etimi ebaye na abusua eya awrawosem na brechire etimi abo ne nyina ene sei unim sa Chairman Wontumi yedi case attack na about summer boy akontama ni ya ye papa kita omose wodi ase ensase ahodo ama nanse ntemeso brane kase etimi to wo sama boy ho a eyi ese edan ahodo na abusua ye president John Dramani Mama na mamwoi ana ose dabi odiye ebeto ye na afensu no wanya konya akokoden etimi ede asotwe kase ede ama Chairman Wontumi wono obo juma edima New Patriotic Party no ai nei brechiri etimi abo na breche nyina etimi boy ya ye papa yi over getting to 2 years ya wadi Cõurt akwani abasa no ene na judgment eba ye se Chairman Wontumi ye manumfie pole 20 years onkoda efiase na 20 years na nkasa no was at 120,000 Ghana city. Ay nei, papa ese tuya etia kahun abusua asem kasiya pa enetimi akokodin esi yeko ni akwakoje ensem no munkyere munyina ediaba sei enetua mu edai enetua mu a Chairman Wontumi ne lawyer apia kubi enya konya ankopia ho na afenso omontimi entwetwa anyen no na bise ebeba so se ebema 20 years na before that ya ene na Chairman Wontumi ebekokopiem Cõurt no na busua rumors ababonten se Chairman Wontumi 20 years imprisonment ene yedema ye papai fofian toata ejabo eja anya babedua Accra High Court a confirm se 20 years in prison ye papa Chairman Wontumi enko nonko dem adem nye Ghana ni ana ene edru ho se Chairman Wontumi enye Ghana ni entino yama no 20 years onko de fiase na abusua yenko ginsem no mu nkyerkyere munyina embra ne hudie ko ene de basem no enya agita.
Almost every time that he comes to court, but he doesn't want to engage the media. Clearly, from his demeanor, he looks quite disappointed at this particular point, knowing that his man is going to prison at the moment. But let's try and see if he would say just a few words here at the High Court after Judge Audrey Kokovite delivered this judgment just a few minutes ago. It took more than an hour reading the judgment here. And Mami, in Criminal Code 4, the whole process began when Charles Boache, who was in court holding the brief of Atachia, and basically on his feet, moving the motion. I mean, basically explaining that they are in court today in order to inform the court about the fact that they filed a motion for a deferment of the judgment because they were seeking constitutional interpretation of some provisions of the Minerals and Mining Act. And they say that if these provisions are not interpreted properly, it means that their client will not be sentenced fairly. But the court dismissed that particular motion. Another thing that happened in court was that the lawyer lawyer also informed the judge about the fact that Atachi is currently out of the jurisdiction, and for that reason, they would, pray to the courts for the ruling or for the motion to be moved to a day after Wednesday, 22nd July. But the judge simply dismissed that as well. And in her view, in the court, she basically said that Atachi was in court the last time when the court sat, and in fact, he initially prayed for more time for him to familiarize himself with the case, the proceedings that went on before he took over this particular case.
2 years for an offense that the minimum is 15, maximum 25. The judge, I think, might have listened to your plea, don't you believe?
Probably she did, probably she did not. Because I was of the view that the minimum sentence was okay. Because I made a point that getting Wontumi out of the picture, that is incarcerating him, may affect a lot of things, especially his businesses, the number of people he employs and all that. So that was the appeal I was making to the court, that yes, the court has come to the conclusion and convicted Mr. Wontumi for all the offenses. But in terms of the sentences, I mean, the court ought to consider his significance in society, especially the chain of businesses he owns. And I also made the point that currently we are struggling with a lot of youth employment. And if the court itself has established that Mr. Wontumi is a directing mind of all his businesses, it means it's very crucial to his businesses. So getting him away from his businesses in giving him such long sentence may negatively impact on the businesses, and the young people who get jobs through his businesses and all that, they'll come onto the streets as unemployed, adding to the huge numbers who are already on the streets with no employment. So that was the appeal I made to the court, that the court should consider this particular circumstance of Mr. Wontumi and probably give him the barest minimum of sentence. That was what I did.
Assignment is by way of a written instrument. And if there was none throughout the trial, and that a person could be convicted and sentenced on, it's really a worrying trend. And what can we do except to consult our clients and fashion out the way forward, and we'll certainly come out.
But the charges were brought under the Mining Act, right?
Yes, certainly it was brought under the Mining Act. But in terms of assignment, the specific legislation of land transactions is the Land Act of 2020. Yes, Act 1036 regulates the conduct of land transactions. So if you want to really understand what assignment means as far as land transactions are concerned, then you have to go to the Land Act. And clearly the Land Act talks of assignment to be a written instrument, but we did not see it. And said clearly, once he has been convicted on assignment without mineral rights authorization, it's clearly mind-boggling, and I am not comfortable with the setting.
You describe this as mind-boggling.
Yeah, it's mind-boggling.
To you, it is unfair. But let's talk about the processes of the trial itself. Would you say due process was followed?
I will reserve some for now.
Would you say the judge was fair and firm and just throughout the proceeding?
I wouldn't want to, with the circumstance I find myself now, I don't want to comment on some of the matters, but I believe that as a legal team of people with his tact endorsement to speak on some of the matters that has gone on throughout the trial.
And that response points directly or hints directly. Is that what I'm sensing?
Oh, certainly. Once you are aggrieved or dissatisfied by the outcome of the decision of the courts, the onus lie on you to file an appeal at the appellate courts. Now, from the High Court, you can only go to the Court of Appeal. And from the Court of Appeal, if you are still dissatisfied, the rules of courts and the laws of the Republic allows you to go up to the Supreme Court. So we will consult with our clients and take their proceedings and go through.
Say so. I mean, this has generated a lot of public interest, and I'm sure that there are those who would be applauding you that indeed you have fought a good fight. Is that how you see it?
Let me get to the statement.
All right, the Deputy Attorney General is trying to position himself well, so that at least we can get one word from him. I'm sure that is a judgment that excites the department, that at least one victory has come, but it might not just be one that the department would want to keep.
Go back.
But because me young people ni okay. Why am a bush and me young people I am a chairman. Etimi must say Wontumi. Etu ama mu boss see Wontumi no. Mesu ama no atete apansam. Eti ya pay ye home. I said you may have Mabuano, sir, 20 years. 20 years will be crack when we are there. I am man, yes, it's any man to cry. Any part of what you are. I said, Nipper be a papa no home channel. I'm in the poor. I'm ready. Yes, we get 2 minutes of which national. The best we have done it. I'm 2 minutes have a show from. It's the idea about what I am.